Very good. Good morning. Want to call to order uh, the meeting of the Governance Policy and Advocacy Committee, which I'm going to start referring to as GPA. The meeting is for June, what's the date today? June 10th, 2021. And it looks like we've got a good number of people with us. Eric, if you'd call the roll, please.
Certainly. Chair Brown.
Here.
Board Member Cole.
Present.
Dr. Pierce.
Present.
Ms. Beasley.
Present.
Ms. Klein.
Present.
Ms. Ellingson.
Present.
Mr. Holt. Ms. White.
Here.
You have a quorum.
Outstanding. Well, thank you all for being here and helping to make sure we have a quorum so we can proceed with this meeting. Something we were unable to do last month. But we have a fair amount of work scheduled for this morning. There are two policies that I think may require a fair amount of discussion. And those are the transgender and gender variant students policy and the policy on controversial issues. The others are more in the nature of conforming to statutory changes and updating certain things. I know that a number of people on this call are here specifically to help us with the transgender and gender variant students, which is first listed. Why don't we start with that?
Would you like to dispense with the minutes first, sir?
Oh, I'm sorry. Yeah, why don't we we have the minutes before us of I think it's 2 meetings ago.
Yes, sir.
And do we have a motion to approve the minutes?
I move to approve the minutes.
Second.
I second.
Roll call, please.
Chair Brown.
Yes.
Board Member Cole. Board Member Dr. Pierce.
Yes.
Ms. Beasley.
Yes.
Ms. Klein.
Aye.
Ms. Ellingson.
Yes.
Ms. White.
Yes.
Motion carries.
Great. All right, now, Dr. Roush, let's move into the agenda item.
We can do that. Once my computer decides it wants to behave itself, we can do that. Okay, there we go.
And this policy 5000 has been before us, and we've had conversation about it. At that point, we had discussed it, and it went back for some additional work. And I'm pleased to see that some of the people who helped with it and worked on it are here with us. How would you like to proceed, Dr. Roush?
I'll give a really, by way of background, the board, when we took it to the board on its second reading, asked that it be re-referred to the staff and then go back to the PRC for further action. So we met again. We had some additional meetings with Kaleidoscope and a few other groups. I'm sure that Dr. Blue and Ms. Beal and Ms. Lillis can help refresh me who all the groups represented. And we made some further modifications, and a few of those that you'll see before you. One is right there, is that we wanted to make sure that it applies to both former and current students, particularly as it relates to the records for transcripts and for diplomas and the like. We deleted the language "and not being asserted for an improper purpose." The feeling was that individuals probably are not doing this for improper purposes, and we didn't want to certainly give that sense. We deleted the but are not limited to. I know that that there are folks. I believe, Ms. Klein, if you're not it, then correct me. I think that you're one who in that category of we don't need to say but are not limited to. Whenever you say including, it automatically just includes those things. You don't have to give the qualifier, but we made that change, and we cleaned up a few other items as well here.
Very good.
We deleted some redundant sections. So this is what's before you today.
Great. Well, thank you all, and for the good work on this. Does anybody on the committee have any comments or questions? Wow. Let me ask one. As I was reviewing this and reviewing this again more carefully, it occurred to me that there are a number of alternatives to the words gender variant. And I'm guessing that those of you who worked on this considered quite a few of those alternatives. Why, if I could ask, whether it's Jimmy or Dr. Blue or, why, how and why did you settle on this particular alternative?
I can jump in, and then Jimmy, if you don't mind throwing in some support. But the primary reason that we settled on this term was because that's the term, once we talked to actual community leaders within the LGBT community, that was the most appropriate term that was inclusive, but still, they're sort of synonymous with other terms, gender diverse, gender expansive, and I think they're fairly, those sorts of terms that may be used together, that they're similar, they have similar meanings, and so that's the one that was suggested to us, and we all agreed that it was fine. But Jimmy, anything else?
That's correct. We decided that the best way to really figure out what term is most appropriate would be to ask those individuals who identify using a term synonymous with transgender or anywhere on that spectrum, that gender diverse spectrum. And so we, Dr. Bloom met with several individuals from the community who represent organizations in the community who work with LGBTQ people. And we met with several people who identify as trans or gender variant, and kind of ran by them some of the options to get their feedback on what would be best from their perspective. Because at this point, we don't have any kind of national guidance. When that comes, then it might be time to re-examine it. But at this point, we didn't have that.
Good. Yeah, I for some reason, in this last review, that caught my eye and began to wonder. So I looked it up and found about a dozen different alternatives, and with some of them were discussions about, why some of them were good or bad. So, I'm fine if knowing that you've gone through that process and that you all agree. I appreciate that.
Chair Brown, this is Wanda Lis. There was just one other point that I wanted to make. There's highlighted language that says this policy applies to both current and former students of the district. I just wanted to clarify one point, and that is, so under FERPA, the Family Educational Rights and Privacy Act, if a person believes that their educational records are inaccurate or misleading, there is a process by which they can ask the district to change those records and challenge what is in the records. There is guidance out there that just because a student may change their name or change their gender, that would not necessarily mean that a school district is required to go back and change their educational records as well, with the thought being that at the time the student was in the district, those records were in fact accurate. So I just wanted to kind of add that piece and clarify that it does not necessarily mean that the district will be required to go back and reissue a transcript or something like that, change all of the former educational records.
Interesting. It sounds, initially to me, it sounds much like the birth certificate discussion, which has finally been changing and allowing for change, which I think is a good thing. And I guess in this situation, I'm wondering if our policy said, as it does, applies to both current and former, and perhaps went on more explicitly to say that transcripts of those who have graduated or who attended Columbus City Schools may request changes on their transcripts, on their records, to conform to this policy. Would we be permitted to do that?
Yes, I wouldn't see any problem with that at all. There could even be a reference to FERPA in case individuals are wondering kind of how that process would occur. And there are several documents on the website and our guide to student success that specifically refer to the FERPA process for changing records.
Does anybody on the work group that helped put this together, was there at any point discussion about this topic?
I don't believe so. And the reason I say that is, as you may be aware, we, Dr. Blue, Jimmy, and I recently presented to the Ohio School Board Association regarding this topic and on the policy that was in draft. And as part of the research that I was doing for that presentation, that is where that information came up, and I shared that information with the audience during the presentation.
Good. Well, it certainly sounds to me like we should clarify the point, and it appears that we have a choice when we clarify it, either to provide for these former students to change those records or not to do so. Any thoughts from anybody?
I've got some thoughts. This is Emily White. It looks to me like the plain language of the draft that we have in front of us already makes that choice and already accomplishes that policy change, because it says it would apply to both current and former students. And under records and references, it says the district will change a student's official record to reflect a change in legal name or legal sex assigned at birth upon receipt of documentation that such change has been made. So I think that if we leave this as is, we have made that policy choice. And I'll also say I think that's the right choice to make, because this is a document that is used for college admissions and employment purposes. And I think it's particularly important in those cases that those records reflect the student's current name, and that they not be basically required to out themselves at the beginning of their education or employment search.
Mm-hmm.
It's not clear whether FERPA would simply allow a kind of a broad stroke policy decision regarding whether those records should be changed of former students. I don't think there's any doubt with respect to current students, because certainly if they have a name or legal gender change, then while the students are in that district, we can certainly make those changes and make those changes to all of the records. It's really the students that formerly attended. And as I said, kind of the thought was that at the time the student was a student in the district, the records were accurate. And I think this probably comes up more so with respect to the gender, because we know right now that it's possible for students to do a legal name change. Doesn't always happen. I mean, we've often identified informal name changes and included those in records, but they can do a name change. What you may want to consider is having reference to or referring those changes or request for changes through the FERPA process. We do provide guidance, as I said, in our Guide to Student Success, and I know there are other locations where we provide the information to students and families as to how they can change the records, or at least make the request to change the records.
This is Board Member Cole. I absolutely agree with that process. I appreciate our forethought with regards to acceptance of all the gender variant aspect of this, but it does make sense for FERPA compliance because for those who really don't know, when our students graduate high school, that graduation is, even in that ceremony, affirmed by the principal, who then says, based on Ohio Revised Code or whatever it is that they say, based on the state of Ohio, the compliance, the State Board of Education, we now confer these diplomas. And we approve that on site. So I think that the whole FERPA, the whole state compliance piece of following a process where they can then make that formal request to have that information changed, or some record that submits from us, even a statement, a letter statement from the district that says at this time the student's name was, John Doe. So I like that. I still want to accommodate that faction of students or graduates who want to request a gender variance designation or a name change, what have you.
Well, at least I think that makes sense. With the one issue that I have with that is that we would routinely include the name that they were known as while they were student together with the new name that they're requesting. And I would think that we would not have a record that immediately disclosed to anybody looking at it that there had been a change. I think that if they've got a new name or new gender or conforming gender, I think they should be able to get the record that way without suggesting that they're going to change, or they could ask for it either way. Anybody else have thoughts on that?
Just one other thought on the FERPA piece, because I've represented folks, challenging their records and using this procedure, and it just strikes me that what you're doing is saying that the existing records are either inaccurate or misleading. It's a weirdly confrontational process that seems to me like an awkward fit, at least from the student perspective of requesting this change. I mean, maybe on the back end, the process that's used under FERPA currently is what should be used by the district to implement the change. But it just seems to me like this is a process that requires its own form. Like I don't know if it makes sense to necessarily for students have them do a FERPA form to request this change. Why not just create a form that works to make this request, just as the state is now having to do for birth certificates, and appropriately so. Because I just don't think that that the district has necessarily done anything wrong for, you know, the kindergarten records in one name, that might not make sense for getting that transcript now.
Any further thoughts on this? Emily, your suggestion would be then, instead of the sentence that's there, to make a change that's
So to simply reference the statute, I don't think is enough. I think we need to reference whatever our internal process is, because FERPA basically says you have to have a process to evaluate parent and student requests to change inaccurate and misleading records. And so for us to just say, it doesn't actually inform an individual who wants to utilize this process, what the process is, or practically speaking, how do you do it? So if we're going to have a form, if we're going to have an office to go to, if we're going to have a written request that needs to be made, we should just say that, because I don't think that just saying you follow our FERPA process is necessarily enough.
well,
I'm sorry. I agree, Emily, because the caveat is there that it's inaccurate or misleading, which in the case of some students, it may not be at all.
Exactly.
And you're right, it kind of sets up this.
And then you have this evaluation process and discretion that's put in there, when really it should be a policy decision that's quite clear and certain. And especially because this policy is saying this is a procedure that's available where a student has already gotten a court order. There should be no discretion involved at that point when a student applies to have their name changed on these records. Nobody should be evaluating whether, well, were they inaccurate, were they misleading, or asking a student to fill out a form that says that to get this change made.
Correct. I agree with that.
Now, can we perhaps, and I guess it's what I first thought before the FERPA provision came up, in the definitions section of this policy, define the word students to include current and former students. And that, I think, would probably solve it and make it clear.
But the policy also, I mean, if you say it applies to current and former students, then you're still using the same term. It's a kind of a tautology to say student equals student.
You are, and it doesn't deal with the real issue, which is the process. So yeah, you can give that sweeping, we can incorporate the definition aspect of it. And I think student is appropriate. Because whether they graduated or not, they attended the district, they graduated from the district, or at the time there were records of report about them as students. So they were a student. I think the bigger issue is as Emily stated, how do we develop, or how do we state that in this policy there must be something, a formal request that requires development of a process for students to, the superintendent shall create a process designed for such record requests based on whatever. And I think something that addresses the process, that directs the superintendent through administrative guideline to develop that formal process. Am I making sense?
Yes, and if I can also add, so in the Guide to Student Success that is distributed every year to every student and or parent, one of the pages in the back of the form is, or the back of the document is called the Parent and Student Sign-Off Form. It's a full-page document which basically explains the parent and student's rights under FERPA, and gives detail about how those records, I'm sorry, I'm looking at it now, why those records could be changed or under what circumstances, and again, gives details as to what the rights are and the right to appeal to the U.S. Department of Education. So we do have information, at least to start, to share with students and former students about potentially changing those records. I don't know, quite honestly, if we have a more detailed form or a detailed process. I'm only aware of during my time in the district of maybe a couple cases where we have had what I will call appeals under FERPA to change records. I do believe, though, and forgive me for not recalling, but I do believe that there is some more formal writing in terms of what that process may be, but I don't have it in front of me this morning. But certainly one of the ways to address that, I think, would be to have the superintendent, through the administrative guidelines, certainly develop or clarify that process. But we do inform students and families of their FERPA rights.
So, Chair Brown, for conversation, I've added 2 sentences here. We certainly can wordsmith this, a little bit more, but I wanted to make sure that we call out it sounds like there seems to be a desire perhaps to call out that we need to follow FERPA. And then also that we need to have some forms and guidelines. And then typically what we do in the policy is we direct the superintendent to go ahead and promulgate those guidelines and those forms so that those are set forth. And I know the team is already working on guidelines in anticipation of this policy. And I think this could certainly be something that we spell out in greater detail as far as what the form is, what the policies are, or what the guidelines are to kind of implement this section of the policy. Is this, am I on the right track, I guess, committee members, with where we're going? Do we need to?
Why do we need to reference FERPA at all here? Why don't we just say that the superintendent, actually there's something here that says shall adopt practices. Can we have just something to say, we'll adopt practices to create a form and develop a process that will implement this policy and respect the confidentiality and all that. So that way, instead of using the word FERPA, which invokes mistake and things like that, we just state the substance of what this is doing.
I appreciate that. I don't know that that's the right way to go about it. I think that including FERPA and, our measure of compliance to that, I think it's important. We always reference whether it's a statute or whether it's federal law in some manner when we're doing our policy where it's relevant. And I think that this is germane. I do. The beautiful part of it is that, again, we are addressing, the substantial issue, which is identifying a process or incorporating inclusion of a process that includes, gender variance and students having the opportunity to get records changed should that have to happen. But I think the incorporation of FERPA is important.
I just don't see what the substance of FERPA is that is germane to this. I mean, there are lots of other laws that, for instance, that we aren't referencing, like Title IX, that also have bearing on how a student treats gender that we don't reference here. And yet the substance of this policy is consistent with it.
And I can certainly share from my perspective in terms of my reason in raising that is that potentially a former student could look at the policy and then think that person could make a request to have every single former record while they were a student at the district changed to a different name and or a different gender. And I don't believe that there's a way to do that other than going through the FERPA process. Because as I said, that the reasoning and the guidance is that at the time the student was in the district and a student of the district, the records weren't misleading or inappropriate because that was their name or that was their gender as known at that time.
Are you saying then that you think that the district should not change records that would still have a dead name?
I am not.
Requests it.
Sorry, I am not. I'm simply suggesting that there should be a process to look at that and consider that. Because it is FERPA, which is federal law, I don't know that we as a district can just automatically change those records. My suggestion is to simply have a process, and it may be the final decision every time is to change those records, but I think that's a decision that potentially should be made by a team or a group of individuals rather than just automatically changing the records.
Can we say, to the extent allowed by FERPA and federal law, that the school shall accommodate the requests of former students?
But are we then saying that a student has the burden of proof to show that the records were misleading or inaccurate? Because if we're my problem with FERPA is that it guarantees a process, but it doesn't provide any substantive criteria for how discretion will be applied in the process. And if we're applying discretion, then suddenly we've inserted uncertainty about whether a former student or a student with a court order changing their name can have access to a transcript. Now it's going to be them having to prove that it was inaccurate or misleading. And I wonder too if there's a difference between a student having to invoke FERPA and all of that process and the district committing that we're always going to follow FERPA. Maybe we could phrase it that way and just say student makes a request and the district will, comply with FERPA in maintaining the records. I don't know. I'm still just very uncomfortable with the uncertainty that's left where the only standard that FERPA supplies is it inaccurate or misleading? And it very well might not be, but it still might be the right thing to do to change these records.
I think the substance of this all is about being as closely as we can and best practice to however general and broad the federal government, because states are allowed to do, they're sovereign as well to an extent and allowed to do and design processes their way. But I think that this is a great first several steps toward best practices with FERPA and Title IX and anything else where this is relevant. At the end of the day, I'll answer for myself here. The second part of what you mentioned, which is the burden of proof. The answer to me is absolutely yes. If you attended Columbus City Schools, or as far back as when Columbus City Schools was Columbus Public Schools, if you attended the district, graduated from the district as a student, and your name was, Sharon Miles, and you later decided that you identified a different way, maybe even went ahead and got a physical change to become Michael Miles. Well, the burden of proof is on you as Michael Miles to demonstrate that why you want those records changed. We went about the official process in accordance to law as Columbus City School District. We did. So yes, ma'am, the burden of proof is incumbent of the individual. Yes.
I mean, personally, I think that goes against, the idea of having this antagonistic process and prove that the records are inaccurate is exactly what we should avoid in this. And once again, I'll just say FERPA does not say that we have to change records. FERPA does not say that we can't change records. FERPA just says there must be a process in place for a student to change records that are either inaccurate or misleading, but it does not provide any substantive guidance about what that process needs to be. That discretion is where the school board comes in to form that policy.
You're exactly right. And that's why we're here on this policy right now, working on designing language with the expectation that within administrative guideline, a superintendent will design the best practices by which we identify the inaccuracy or lack thereof.
Let me ask you this.
Emily,
yeah.
This is Jimmy. I just wanted to throw out something with regard to the piece that you're bringing up, whether something is misleading or inaccurate. If I'm a student and I come in to pick up transcripts, and those transcripts, as they're printed currently, do not reflect my name and gender accurately, as I've been through the court and had my birth certificate changed, then if I take those records at that time, they would be misleading or inaccurate because they wouldn't accurately reflect who I am currently according to the courts and even according to a birth certificate. So I think it still applies, and I don't know that it would necessarily have to be antagonistic, because what we're doing is saying, if I take those anywhere right now, give them to a college or a higher ed institution, give them to a place of employment, it would be inaccurate or misleading at that point, even if it wasn't.
I fully agree from the student perspective. I absolutely agree. But what I worry about is this is a policy that's going to give guidance to the district on how they review and assess these changes. And are we empowering somebody to say, I don't think it was misleading. I don't think the school did anything wrong in having these records reflect an old name, and therefore I'm not changing it. And whereas right now we have it written, the district will change the record to reflect a legal name change upon receipt of documentation of a court order. That to me seems like I would be entirely comfortable with the district saying, in every case where we have a court order changing a name, we'll change the records. And I just don't think there should have to be like this, proving that it's misleading or inaccurate.
Emily, do you have a suggestion for language? Perhaps what Dr. Rausch has written in that place at the moment.
I think it would be good enough to leave the existing language that already says the district will change a student's official record. And we've already set up front at the top of the policy that this applies to current and former students. So student is already covered. And so if we think that additional guidance needs to be given to the superintendent to make sure that a policy is put into place here, then or a form or a process, I think is probably the better word.
Yes, the
then
process.
We can add that.
Yes.
Yeah, but do we want to tie their hands with what the form looks like or how it looks? I just fear that expressly linking it in this policy to the FERPA policy, which is just an awkward fit for a variety of reasons, it would be a mistake. But let the folks who will actually implement this policy do it. But let there be no question, when there's a court order, you're going to get your records changed and you're going to be okay. And you're not going to have the humiliation of having to apply for a job and have these records that out you.
Well,
then that's where that burden of proof piece comes into play. But I agree with you. If they legally made the changes required that allowed them the opportunity to not be outed and their privacy acknowledged, and coming to us with a request to change name and or gender, I don't see a problem with that. I don't see a problem with it if a child, if a child, and that means K through 12 for me or pre-K through 12 for me. So if a youngster said at 8th grade or 9th grade, that I want to change my name to, from Michael to Michelle, and I identify as a female or I don't identify as anything, then, we should be able to do that. A parent should be able to, fulfill that process.
That happens routinely, by the way, when people get adopted, when they get married. None of my educational records match my name currently. So, and that's true for a lot of people. But this process is supposed to.
But you got a legal paper. You did that legally.
Yeah,
I hear what you're saying.
But this process puts that in the hands of the students, who I think are appropriate. I don't think it should be for the district to be evaluating that choice once we have a court order here. If somebody needs this, I'm going to trust their judgment. I'm going to trust that they need it. And I think that we should make this process as quick and painless as possible, so that there isn't this element of uncertainty.
I think we're making an argument and case for something that's, interestingly, in public policy, common sense is never common. But because of the processes that we have in place where we formally acknowledge, legal documentation of something, I just don't understand where your argument has, is without merit, but needs to go as far as it's going in discussion, because we honor these types of things already.
So is our best option simply to make no change, or to include the now relocated statement that Eric has provided? The superintendent shall adopt a process to implement such changes.
And they did that because we also have
works.
something down here saying that we've got a birth certificate that's changed or is changed by a court order. I'm like, we should probably drop it, make it its own paragraph, so we don't tie it to one and not the other, was my thinking. But I'll let the other legal minds tell me if I'm doing that right.
Well, anybody? Is this statement accomplish what you'd like?
I think this works like just as is. I think honestly, I think that the draft was great as is. Adding this, adopting a process, I think only makes it stronger.
Anybody else?
I think the other thing to keep in mind, I think we do need a process through the administrative guidelines, the superintendent's authority, because there are going to be details such as what happens to that document when a former student, document being name change or gender change, that the student wants to present it to the district. Quite often that is done electronically, maybe they're out of state. And so I think we do need some kind of process in place so that everyone knows exactly what's going to happen to those records. Where are the official legal documents going to be stored? Who's going to have access to them? Because those are all important points when you're talking about changing records and then kind of no one finding out about the change. So I think we can do that within the superintendent's process, but I still think there are some more details that we need to work out, but we can do it through that process.
All right. So you're not suggesting that we need anything more to be changed in the policy?
It doesn't have to be.
Okay. Are we okay with that provision then as is, and we can move on?
Yes, sir.
All right.
To be clear, we want to add this sentence in here, or we feel that the policy is fine as is and we don't need to add anything. I just want to be clear.
Incorporating the statement that you made about superintendent will design, through administrative guidelines, a process. Yes, that language should be incorporated.
Thank you.
And we're all in agreement, I believe. So let's move on. Anything else in this policy? And I have a handful of very minor changes, mostly grammatical.
Mr. Chairman, I have
to quickly review them or not? Go ahead, Joellen.
Yeah, I have a question about the paragraph regarding dress code. So I'm not familiar with policy 5511, which is fine. I'm somewhat familiar with the guide to student success, but my concern here is not the paragraph, it's fine. If the dress codes that are on the CCS website are changed to reflect non-gender specific dress, because currently Under many of the schools, it says boys, girls, male, female, young lady, young gentleman. And I think that we need to be consistent across the board and take out those gender specific names in our dress codes.
Yes.
That was it.
And I would just add to that, I agree, Joe, Ellen, those items that are in our dress code that are kind of related and call out gender should be consistent, and we should definitely go back and review policy 5511.
I just had a broader question.
I agree with that, and I'd love to include students in that conversation in some part of that process. I'd like to include their feedback. I think that's going to be seminal to, how we further shape that policy. So thank you.
Dr. Rausch, I know this, where to begin? We know that at our state level and at state levels across the nation, trans people are under attack. And I know there are a couple of bills in Ohio directed at athletics, and you obviously spend a lot more of your time tracking that sort of legislation than I do. And I'm just curious if you are aware of which, if any, provisions of this policy relate to current legislation at the state.
If you look under OHSAA activities, since at this point in time, the legislation that's been introduced is focused on athletics, primarily on saying that those born biologically male are not allowed to participate in girls' athletics. It would be that particular section. OHSAA already has a policy for this. When we agree to abide by all the OHSAA policies, is that when we join them, that's the whole rule book for everything that has to do with athletics. And so that would be the only area that, depended upon if that legislation were enacted. I don't have a sense of where that's going. You are correct. It has popped up in about every state at this particular point in time. It has received sponsor testimony in the House, which is, I think you may recall, is required under their rules that anything introduced prior to the April of the even numbered year gets at least one hearing. It has not been set forth, scheduled for a second hearing at this point in time. The Senate has been embroiled with the budget and has spent most of their time there. I don't believe they've even taken up their version of it. And so that's where we stand at the moment. We'll continue to watch and monitor that. There's also some I think litigation going on across the country in this particular regard. So we'll continue to monitor that as it relates to our policy as well.
Okay, thank you.
So that would suggest that we can go forward with this policy as it now is, and deal with any new laws as they're enacted. Is that right?
I would say yes.
Okay. Anything else with this policy, or are we ready to proceed? And I did look through the items that I mentioned that are grammatical, and they are all grammatical. And if you're willing to allow those changes to be made following our recommendation, or I'm happy to read them through if anybody would like me to.
If the committee's okay, you can simply, I think, move that any grammatical issues be resolved.
I concur with Dr. Rausch.
All right. Do we have a motion then to adopt this policy with the change that's now stated, this new sentence that we've added?
Motion to adopt the policy as changed.
And
I second.
subject to any gender or any grammatical differences. All right. We have a motion and a second. All in favor? Say aye.
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 Michael Cole, aye.
And I'm an aye. Any opposed? All right. This policy is recommended back to the board. Thank you all.
If we could take up the evaluation policies really quickly, I don't think they'll take too much time.
That's fine. You want to do everything other than the controversial issues at the moment?
I'd at least like to do those 3 evaluation policies. We can go to controversial issues after that, if that's okay with you then.
Well, let's get those that you'd like to address.
And I'd like to do that because we'd like to get these in place before the next school year.
Fine.
These are largely, and I'll start with, I'm going to go ahead and share my screen again here. We'll start with 3220. This is due to statutory changes. OTES 2.0 was put into effect. This has gotten delayed given COVID-19. These are conforming changes. We reference again that we're moving into OTES 2.0. This language here is directly from the statute that's there. We fixed, we had peer review and assistance. It's actually peer assistance and review. So we fixed that particular flip-flop of words there, clarified that the professional development is related to the evaluation process. Again, kind of took out his, hers in there, and then clarified that these changes will go into effect the following school year. I know that our employee relations team had a conversation with some folks from CEA. I think Mr. Hayes is on the phone right now. Thank you, Jimmy. I believe Mr. Hayes is on the phone as well. Carrie Mullins, also from CEA, helped. She actually identified that we added another policy that we'd missed some conforming changes to, but wanted to make sure that we got this in front of everybody so we can get this in place for next school year. That's what I have on this. Similar changes to the other 2 policies.
Dr. Roush, this is Joellen. In 3A and 3B, or 3A particularly, it still says it's her most recent evaluation. Can we change that to teachers?
Thank you. I missed one. I appreciate it. Thank you. I also noted that I left some numbers in. I know we don't like those either, so.
Anything further on this policy? Do we want to take all 3 of these together?
Yes, please, Mr. Chair.
Yeah. Let's go to the next one. Dr. Roush.
Moving to the next one here. So we have licensed support professional, clarifying it's an individual eligible member of the CEA, fix the peer assistance review, again, the professional development related to the evaluation process. And these are everybody who are not a teacher or a counselor, because the counselors have their own policy per state law. So these are your social workers, your school nurses. Mr. Hayes, can you give me another example of who else this may include? Social workers, school nurses?
Psychologists.
Psychologists.
Or related service folks.
Thank you. And then
Dr. Rouse, can we go back to that one at 4? I think B, there was a his and hers in there. 4A.
Thank you.
And then there's some numbers in that one.
Just when I think I catch some of them, I always miss a few. And again, we fixed the peer assistance review.
Mm-hmm.
Assistance and review.
Now, I know with another policy, we discussed the accomplished and the skilled as it related to our, I want to say our teachers, or maybe I'm recalling incorrectly, but I recall us having that conversation and not sure where we landed on keeping that. I was a supporter of keeping the accomplished and the skilled definition. So we have kept that with our professionals, our support staff.
Yeah, these are the ratings per OTES that are in. Those are the levels per statute. I think what we were referring to as we were talking, it was another policy and it had to do with highly qualified, which was a federal definition. We did not modify that policy at this point. We've got to still go back and have that conversation. Just with everything going on, we hadn't quite gotten back to that yet. So it is in the hopper, if you will.
Awesome. Okay.
And then under counselor, again, the change here, full-time eligible bargaining unit members, peer assistance and review, PD related evaluation process, members evaluation through the joint panel, expedited the members. So we got rid of that, his, her. I'm going to make sure we got rid of all the others. Nope, we got.
So I think at
this was
3A and B, you have his and her.
We are slowly getting all of the his, her references out of the policy manual. So those are the three.
All right. Any questions on any of these three, or are we ready to proceed?
Ready to go, Mr. Chairman.
Do we have a motion to adopt all three of these policies with the changes that have just been suggested?
I motion that we adopt all three policies, 3220, 3220.03, and 3223 as amended.
I second.
All in favor, say aye.
Aye.
Michael Cole, aye.
Any opposed? All right. Got three more.
Now we'll go to controversial issues.
Yeah. And we've got about a half hour.
Okay. So this in short, when you may recall, House Bill 164 from the previous General Assembly went into effect. We dealt with this under, I'm trying to remember there were a couple of other policies. I know one was in the 8,000s. It was religious and patriotic ceremonies and observances. There was one other, because of the change, there was some, the policies limited kind of the exercise of religious expression only to non-instructional time or periods when they were free to associate. 164 removed that provision from law. So we simply are removing that provision from our policy as well. We've already tackled this in the other policies. Neola didn't catch it and brought it up later.
Oh, thank you for the clarification. Render unto Caesar that which is his.
Further questions, suggestions? This one I do have, I think, three grammatical changes. And we can deal with those later.
That's fine.
Hearing nothing further, do we have a motion to adopt or to recommend the adoption of this policy 2240?
With the grammatical changes, correct?
Yes, with the changes that I'll provide.
Motion to move forward to the board recommendation for this policy upon grammatical corrections.
Thank you. Do we have a
I
second?
second.
All in favor signify by saying aye.
Aye.
Michael Cole,
Aye.
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 Any opposed? All right. And we can get to the rest of these.
We'll jump into 6220. The only change is to add the /CFO after the tax budget preparation.
I don't hear anything. Everybody's all right with that? 6220, the next one?
Okay. You want to do do you want to at least have a motion and a vote on 6220?
Or we can take them together.
The others are all a little different.
Okay, well then, with respect to 6220, do we have a motion to recommend this?
Motion to second.
All in favor signify by saying aye.
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 Any opposed? All right, we can
Michael Cole, aye.
move forward. Next would be what, 7450?
7450.
Or whatever order you want to take them in, Eric.
7450, we'll go ahead and keep them in order. This is I may phone a friend with Mr. Sinkowski. This is due to a GASB update federally. It kind of changes the property inventory. As you can see down here, it adds H&I. One is stating that proper sales procedures will need to be established to ensure highest possible return. And then when original or replacement equipment is acquired under a federal award, so this is under federal grants here. If there's no longer a need, we have to dispose of it in accordance with CFR 200.313. So this was a federal law change.
Okay.
The next one's GASB. I'm sorry.
Dr. Roush, or
Yes.
excuse me, Mr. Chair.
Yes.
We could motion to move this forward motion to move this forward for recommendation pending any needed grammatical corrections.
I just had one question, actually.
Yes, ma'am.
Just curious if, I guess I don't know the specific differences between the contracting requirements between the city, but I know that we're permitted to choose the best offer sometimes. And so I'm curious, since this says the highest possible return, does this functionally change the way that you do business in this specific area?
With regards to real property is governed differently. I guess I should say real estate is governed differently. We are subject to having to offer real estate to community schools first. They have the right of first refusal. Beyond this, I don't believe that it necessarily changes, but I'm not necessarily. I ran it through our CFO folks, and they were okay with it, so it didn't seem to raise any concerns with them. I know with real estate that's different, though.
Okay, thanks.
So this would apply to other items such as equipment, trucks, vans.
Any further questions? We have a motion already. Do we have a second?
Second.
All in favor signify by saying aye.
Michael Cole, aye.
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 Any opposed? All right, this one's approved for recommending to the board. And finally, 7455 accounting system.
Yes, for capital assets. So these are again are land, buildings, facilities, equipment, intellectual property. This is, I think, was kind of, I think, again, GASB kind of caused a change in some of these items here. I don't know if Mr. Sinkowski has any other items to add to this. He's more of our GASB gap expert. Perhaps he doesn't.
I do not. I'm familiar with GASB, but would no way qualify myself as a GASB expert, but thank you.
I hold you in high esteem, Kevin, perhaps higher than you hold yourself. But
yeah, I mean, if these are things that are just as a change, I know GASB was making some changes to some of their stuff. I don't know the specific provisions, and if this is just to comply with the terminology, more or less is what this looks like. That's really all I have to offer.
And I think part of this also may have come through OMB as well at the federal level. So.
Mr. Chair and Dr. Roush, Kevin, does the audit, does our auditor need to, our internal auditor need to take a look at it just as final eyes?
Do you mean Carolyn? I can run
Yes.
this by her. I don't think she's looked at this specifically, but I can definitely run this by her if you would like me to, prior to you folks taking action on it. Like I said, when I read it, it looked like it was mostly just kind of compliance with maybe some language changes and things of that nature, but she would be a better expert from a substance standpoint.
I'm fine with that if you would like to go that route.
Yes, Mr. Chair, I would recommend that.
Very good. I will usher that through her.
I have no problem with that.
So that's what we have on the agenda for today, sir.
Yes. Does anybody have anything else? I've got just one announcement. And that is, and I'm glad we've got Dr. Roush here, we will soon be moving back to in-person. And based on what I heard yesterday on the Finance Committee, it's been pretty well thought through. And starting in July, which would be our next meeting, we'll meet in person at 3700 South High.
Actually, we have July off.
Oh, okay.
So
July off. So we'll meet in August at our South Campus. Yet to be named, but it's 3700 South High. And we'll have a large room where we can all socially distance, and the staff there has done a spectacular job with school board meetings and otherwise about making sure that we're all safe, and we'll be wearing masks and things of that sort. There will still be an opportunity if anybody is unable to attend in person and wants to call in or Zoom in, they'll be able to do so, but those folks will not count as part of a quorum. We still will have the need, we'll need to have a quorum present in person, and those folks online or on the phone will not be able to vote, but they can participate in the discussion. Everybody understand all of that and have any questions? Awesome. Well, in that case, thank you to all of you for another good year of service, and have a wonderful summer. Continue to be safe, and once again, thank you.
Thank you. Much love to you all.
All right.
Thank you, everybody. Have a safe summer.
Thank you.
We are adjourned. Thank you all.